We want to welcome people to this webinar with Lusk Albertson, and our panelists with us today will be coming Miller Davis on the 31st, but today they're still Lusk Albertson. But thank you for joining us for Leader to Leader regarding back to school, return to school handbook things, and addressing some of the legal questions that you have as we're reopening. If you haven't already, please do take a moment to introduce yourself in the chat and let us know who you are, where you're from, what you're looking forward to, maybe a hope for the day or a question you want resolved. We're going to be have a panel of our attorneys from Lusk Albertson, and then from there we're going to have Tammy Jackson close up with some things that we can do to support you around the culture and dealing with students. So that's our agenda today. So if you haven't already, please do take a moment to introduce yourself in the chat. While you're doing that, I want to remind you that although we have attorneys on, they are not your retainer client, or you're not necessarily their retainer client. So they're talking to you in general terms around what's legal and what's not, but they are not giving you official legal advice. So this is not to say that they are your attorneys. Those are things you have in a client, attorney-client privilege with, but we are giving you what we believe to be legally responsible and appropriate based on what we knew as of this morning. From the executive orders and the back to school and all of those pieces. So as we go through today, please do note that we're here as your thought partners. If you have questions, please do add that under the Q&A function of the tool for us. And then from there, also know that we are recording this. So please do not write or post anything in the chat or that you wouldn't want your mother or child to see. With that then, please do use the chat to introduce yourself, where you're from, what you're looking forward to, any hopes or questions, and then really from the chat or the Q&A function for questions you want that haven't been addressed as we go. So with us today is Kevin Sutton. He's the managing partner of Lusk Albertson, soon to be Miller Johnson, Adam Walker and Anya Lusk, who are associates with Lusk Albertson, and then at the end will be Tammy Jackson, our program manager. I'm Colin Rittmaster, the Associate Executive Director at MASSP, and I'll be helping to moderate this. So without further ado, I'm going to stop sharing, and Kevin's going to share his screen with some visuals for us.
All right, Colin, well done, man. That was robust, and I want everybody to know Colin wrote that disclaimer. The attorneys didn't even write it, if you can believe it. That was quite a disclaimer, but a well-placed message, and we appreciate it. And we appreciate, as always, our long partnership with MASSP and the opportunity to join you today. As Colin said, I've got a couple of my colleagues, Adam Walker and Anya Lusk, with us, and we're going to try to break this up a little bit. As engaging and as exciting as it is to listen to my voice, I know sometimes it's helpful when you can hear a couple of different other people as well. As Colin said, use that Q&A tab. We'll try to address those as best we can. And so we're going to break this out. Colin and I talked about little pods of questions, or little buckets of questions, if you will. And we're going to talk about Title IX, question about lately. We're going to talk a little bit about HIPAA and FERPA concerns, which is out there, some staff issues, some issues you might be seeing as we start to get back into this return to work environment. And then we're saving the best for last. We're going to our mask FAQ. We know there's lots of questions about masks, and so Anya is going to take that at the end, and we're going to try to cover everything we can in the time that we have together. And so I don't know if I drew the short straw or not, but we're going to talk about Title IX first, and I'm going to try to be brief here. And we could spend hours talking about Title IX, but we're hearing a lot about that these days, right? Why are we hearing so much about it, and what really is the key? And so very, very briefly, from a 60,000 foot perspective, I just want to give you a little bit of insights on Title IX. Title IX was passed back in 1972, so it's been around for almost 50 years. So the existence of Title IX is not new, but how we're looking at it, how we're applying it, that's what has changed over time, including the new regulations that we'll talk about in a second. So Kevin, what's this all about? The key language is what you see there in front of you. No person shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. That is a congressional mouthful, okay? But what they're telling us is if you get federal money, You all do. We want an educational environment that is free from sex-based harassment. You cannot discriminate against students on the basis of sex, which means we can't have sex harassment, we can't have sexual violence, we can't have sexual discrimination in the school setting. And if those things are happening, that runs afoul of the mandates of Title IX. So back in 1972, they were thinking about sports, right? We have an equivalent number of boys and girls sports. Today, in the more modern context, we're thinking about, I think, what it was truly intended for, of sex harassment, sex violence, sex assault, and a lot of the issues that we've had, a lot of the debates that have been happening over the last couple of years about our LGBTQ student population has been based on that phrase, on the basis of sex. And what does that mean? I could go on ad nauseum about the topic, but that's what Title IX is all about. That's what is prohibited in the school setting is sex-based harassment, sex-based discrimination, and that is the call of Title IX. So what's everybody been talking about lately? If it's been around for 48 years, in May, they issued new regulations, and that had been a long getting to new regulations. They issued these new regulations back in May in the midst of a pandemic when everybody was closed, and said, okay, here's the new regulations, which is all the guidance from the U.S. Department of Education on how we're going to apply Title IX in the schools, what we expect you to be doing from an investigative standpoint, from a response standpoint, supporting the complainant, supporting the perpetrator, so on and so forth. Those new regulations took effect August 14th. So if you're like me, you've lost track of what day it is, but August 14th was 2 weeks ago. So they passed it. They're already now in full effect. The regulations themselves are over 2,000 pages. We've been doing lots of training on those recently, and those trainings are 2 or 3 hours long. I got about 10 minutes to talk here, but there's a couple of key things I want you to know about. There's some new vocabulary that the new regulations give us that you need to be mindful of. There now is very formally a definition of what sexual harassment is under Title IX for the very first time. That is detailed in the regulations. We have a requirement to respond in certain ways, and we have to have a Title IX coordinator. And so trying to unpack this very, very dense topic in the time we have together, let's talk about a couple of these key components. So the new vocabulary, for years of us doing sex harassment, Title IX investigations, we heard names victim and perpetrator, or alleged victim and alleged perpetrator, or some derivation thereof. The U.S. Department of Education has told us unequivocally in these new regulations, we're going to talk about a complainant and a respondent. And I think those terms were chosen very intentionally. First, they sound very legal, which I think is intentional because we want it to sound like it's serious and that we're talking about legal compliance. So that's number one. But number two is look at the definitions. Okay, a complainant is somebody who's alleged to be the victim of conduct that could constitute sexual harassment, and a respondent is an individual who's been reported to be the perpetrator of conduct that could constitute sexual harassment. There's a very deliberate attempt here by the U.S. Department of Education to have there not be stigmas attached to the labels that are used with these individuals. For the respondent, that there's a presumption of innocence, that they're not a perpetrator because we haven't done an investigation yet, and that a victim isn't a victim yet, they're just a complainant because we have to investigate and find out. And in a longer training, we could talk about why they have those dynamics, but the key is here, these are the terms that we're going to use in Title IX context when we're referring to the parties that are involved, complainant and respondent. So the headline that came out on May 6th when the new regulations were released is, for the first time, Title IX regulations define sexual harassment. And you got to be thinking, well, wait a second. This thing's been around since 1972. You're telling me they never defined sexual harassment before? Shockingly, no, they had never defined sexual harassment specifically in the regulations before. And again, there's a lot of reasons for this on how we got to this point, and today is not the right forum to go through all that. But what they told us in these new regulations is that the sexual harassment under Title IX is a three-part definition. And the first prong you see there is what we normally think of as quid pro quo sexual harassment, conditioning aid, benefits, or services on somebody's participation in unwelcome sexual contact. So that's the creepy stuff that you would think of. If you do A for me, I'll give you a better grade. If you do Y for me, I'll give you a promotion or give you a new job. Those are the types of quid pro quo things that they're talking about. That is part of the definition of sexual harassment. Let's jump down to the third prong. Sexual assault, dating violence, domestic violence, and stalking, as those terms are defined by some federal statutes, All of those things are part of what sexual harassment is under Title IX. That stuff generally comes into play in the post-secondary world, part of the definition. The key in the K-12 setting, what we're mostly going to see, is the second prong. Sexual harassment is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. Again, I know that's a legislative mouthful. The history here is that is the exact definition that the US Supreme Court gave us back in the late 90s in a case called Davis versus Monroe. And what the US Department of Education had seen over time was that as their enforcement arm, the Office for Civil Rights, was enforcing Title IX complaints, they were moving away from the Supreme Court's definition. And so part of the reason why they've defined it here in the regulations is so OCR can't move away from that definition anymore. So they've implemented the Supreme Court's definition. And if it sounds like a really high bar, it is a very high bar. A reasonable person has to look at something and say, oh my goodness, that's so severe and so pervasive, meaning repetitive and offensive, that it has the result of denying somebody the opportunity to access educational programs and opportunities. Again, in a more extensive training, we would break down what all that means. But the key here is that they're telling us that this definition, which has 3 prongs, is a very high bar for someone to show a valid claim of harassment, sexual harassment or sex-based discrimination under Title IX. So what do we have to do, Kevin? These new regulations sound crazy. They are kind of crazy and they're very detailed. And I'm taking one slide to break down 2,000 pages. But basically what we have to do is if we are a recipient, meaning a public school district that gets federal money, with actual knowledge of sex harassment in one of our programs or an activity, we have to respond promptly and in a manner that is not deliberately indifferent. That's a double negative, and I hated those in law school and I don't love them anymore now. So what does that mean? Well, deliberate indifference from a layperson's perspective is like sticking your head in the sand. I heard about something, but I don't want to know about it, right? Cover your ears, cover your eyes, and try to pretend it didn't happen. That is what deliberate indifference is. We say, well, Kevin, that doesn't sound so bad. I think if we know about something, we're probably not going to stick our head in the sand. We're probably going to do something about it. And that means we should be okay, right? Generally speaking, yes. But the key and the reason why these regulations are such a big deal is that phrase, actual knowledge. Actual knowledge before 2 weeks ago meant if your Title IX coordinator knows, if the board knows, if a central office administrator knows, somebody who's in a position to fix things. Now the new definition of actual knowledge means anybody who works for the district. Let me say that again. Anybody who works for the district can have actual knowledge on behalf of the district. And so if we have a parapro that hears about something or gets a complaint from a student or knows about something and doesn't tell anybody, it just got a lot easier to be deliberately indifferent, because if we don't know about something, we can't respond. And that's the huge issue here. That's the big tamale in all of these new regulations, is that we've got to make sure we are providing training to all of our staff members on Title IX. So they know what it is, they can identify it, and they can let a building administrator or somebody at central office know, and then we can get the wheels moving on our Title IX process. And so that's why this has been such a big deal. That's why there's been so much dialogue about it over these last couple of months. This actual knowledge piece now applies to everybody, and that is a big, big game changer.
So 2 questions for you real quick. The first one is this. In mandatory reporting, whoever hears it for those mandatory reporting things have to call DHHS or Child Protective Services. With this, though, specific to possible harassment versus the mandatory reporting for the other, this you could report to a Title IX officer or your administrator and be appropriate.
Yeah, that's a fantastic question. I like people thinking about this like the mandatory reporter obligation. It's not quite the same, but thinking about it that way is a really good way to think about it. The if you see something, say something kind of mindset that we have to have. So in that regard, everyone is on the right track, if that's the way, and sort of the urgency I want our staff members to have with it. But from a reporting standpoint, Colin's absolutely correct. We just want to get it into our system. We want to get it to a building administrator, get it to the Title IX coordinator, so then we can start the process. I have full confidence that nobody's going to sweep anything under the rug. We're going to be responsive and investigate when we hear about things, but we got to know about them. And so you don't have to call it an administrative agency, but you do need to tell an administrator and get it into our system with our Title IX coordinator so we can take care of stuff. Absolutely.
So mandatory reporting, yes, see something, say something, but you say it to the agency, the outside agency that you're required to do. For sexual harassment, see something, say something, report it to whoever in your district's responsible.
Absolutely.
Second question, if a complainant alleges sexual assault and police are contacted and ask you to delay Title IX investigation so I don't tip off respondent, what's the administrator's responsibility, timelines? Is this a violation of Title IX? So like there's this yin and yang between police officers and this. So deliberate indifference, if now the police are intervening, are we no longer indifferent, or do we have other responsibilities while they're doing that?
Yeah, man, Colin, I wish we had like 3 hours because that's a really great question. I could really unpack it extensively, but let me answer the question. Just because we've gotten law enforcement involved on something doesn't absolve us of our responsibility under Title IX. Remember, the police are looking for violations of the criminal code. Did a criminal sexual assault occur? That sort of things. We're looking at our policies. We're looking at our student codes of conduct. We've got to make sure we're adhering to our obligations under Title IX. So from a big picture perspective, simply because we've called the police does not alleviate our responsibility under Title IX, which may exist. And a lot of times things that happen off campus between students can manifest themselves in the school environment, and that Title IX responsibility will be present. That being said, okay, Kevin, I got it. I've got to be prompt. Does that mean that I shouldn't try to cooperate with law enforcement? You know, look, our officers do a great job. Our liaison officers are wonderful. I try to be understanding. A lot of time they're going to have a care house interview or some sort of forensic interview, and then they want us to hold off, and I get that. The guidance from OCR gives us a little bit of flexibility. It talks about prompt, at least starting a process. But I think if there's an issue like that, where there's going to be a forensic interview, I don't want to wait days and days and days and days. But I will try to be cooperative because we certainly don't want to disrupt the police investigation. But at the end of the day, the Title IX responsibility is ours, not the police's. And so those are things you want to consult with your legal counsel about. Again, I'm generally receptive to cooperation with the police, but within reason, because we got to do our thing from a Title IX perspective to keep us protected.
Thank you. Those are the questions we have for Title IX.
Okay,
and
great.
I think you have a training that's available online that people can do.
Oh, we do, and I'm about to get there, Colin. But thank you for the lead. I appreciate it. A couple other odds and ends here that you see in the bullet points, and what's going on here is a balancing act, right? They're setting a really high bar for proving a case if you have a claim, but they're trying to lower the barriers to access. Anybody can make a report, even if they're not the alleged victim of the conduct. You can make reports by mail, telephone, in person, so on and so forth, and can be made at any time, including non-business hours. So they're really trying to lower the barriers to access while having a pretty high threshold for proving a claim. And so what do you need to do, okay? Again, we're condensing hundreds of pages of information into a few slides. You've got to make sure your district has appointed a Title IX coordinator officially. A lot of districts just have them appointed, but their title isn't on anything. Somebody's got to have it on their business cards, in their signature file. They have to have the job title of Title IX coordinator. It's got to be official, and it's got to be public, and it should be posted on your website. We kind of think of training in two components: awareness training, which is making everybody kind of aware of what Title IX is and what the obligation is. You're going to want to move towards awareness training for all staff members. All staff members are going to need it. What we call coordinator training is learning how to move through an investigation, a Title IX investigation under the new regulations, what meetings you need to have, what forms you should be using, how you should be communicating with the parties. We think all administrators should have that, not just the Title IX coordinator. We think everybody should be doing that because that is really, really good. You need to have an updated grievance procedure. For Title IX complaints specifically, the regulations are very, very prescriptive and very, very detailed about what needs to be in that procedure. You're going to have to create forms or new forms if you have old ones to make sure that they're matching up with the new grievance procedures. And you're going to want to create a Title IX resource page on your district website, which has who the coordinator is, how to contact them, copy of training materials, copy of complaint forms, copy of your policy, copy of this grievance procedure. So there's a lot to unpack. And since Colin gave me the opportunity, I will say it. we've got all of this done for you. If you're interested, we've got an awareness training for all staff that we can send out with a click of a button. Same with coordinator training, same with the procedures and the forms, and all of the PowerPoints that you need to post on your website. We've got it in one click. We give it to you in a Google Drive. You can email us at info@luskalbertson.com if that's something that you're interested in, or always give us a call or shoot us an email.
We do have one other question that just came up around. So when it comes to Title IX investigation, it's beyond just like in like an asynchronous or a synchronous learning environment. And let's say that something happens off campus or online on a non-school sponsored website. Are the schools still required to follow through with the investigation? Does that have to do with the nexus to school?
Yeah, absolutely. And what I like in this too is the parent who shows up when we could show up at school. When a parent who shows up at school and says, look at this Snapchat that was going on between my daughter and this other girl this weekend, or this Facebook exchange that was going on. What are you going to do about it? Well, I mean, legally, we probably could say, not really our problem. Happened off campus, happened outside of school, but we very rarely do that because we know that whatever the issue is between the two students can very well manifest itself in the hallways, right? Somehow, some way, during passing time or whatever. And so typically we're proactive on that. Here, I think about it kind of the same way, Colin. I mean, do I think that legally I might be able to make an argument in that moment that it's not really our problem? Maybe, but I think that is leading us potentially down a very bad path that could turn south on us very easily. And so I like to be proactive and minimally have our coordinator or whoever is our quarterback on these things, bring the student in who might be the complainant and talk to them about whether they're okay, do they need supportive measures, schedule change, locker change, lunch change, whatever, and what is it that we can do? And if they ever have any feelings where this situation is coming into the school environment, they know where to go. I think that sort of proactive approach is going to be much better for us in the long run than a reactive approach. Most of these Title IX cases we see are where districts either ignored or underreacted early, and then all of a sudden the complaint comes 12, 18 months later, and we say, well, goodness, we thought everything was okay, but they never really reacted at all. And so I like a much more proactive approach to eliminate any Title IX liability. And again, I could lecture on that for hours, but I like being more proactive and responsive. All right. With that, and I know that was kind of a blitzkrieg on Title IX, I'm going to hand off to my main man, the bearded man, Adam Walker. Adam, take it away.
And this is not going to be any less of a blitzkrieg than what you just did. I'm going to cover HIPAA in a slide and FERPA in a slide. And as many people know, HIPAA is sort of this scary statute because it's very, very dense and very long. And all we really know is that it's about medical information and the disclosure of medical information. The good news is, and I'm gonna cut back on this in a second, but the good news is that usually you don't have to worry about HIPAA much. That's because HIPAA is not usually something that applies to schools for two reasons. One of two reasons. If we're talking about students, then usually there's this whole FERPA carve out for HIPAA. But even before we get to FERPA, if we're talking about employees, if we're talking about students, you have to be a covered entity under HIPAA. And what does covered entity mean? It means your healthcare providers or your healthcare clearinghouses. Now, don't go running off, saying this attorney Adam Walker said I never have to worry about HIPAA. That's not true. That's not true. There are times when HIPAA come into play, particularly if we are talking about school districts, usually medium or larger size school districts. There's some of them in the state that do self-funded insurance programs, self-insured health programs. When situations like that come up, you might have to worry about HIPAA. And that's not all the time. We're in a pandemic, as everybody knows, and there are health and safety emergencies that allow the disclosure of information under HIPAA. But I guess my point is, when we talk about worrying about HIPAA, I don't want your first thought to be, is this form that I'm sending out for a remote learner to fill out? Is this something that is going to violate HIPAA? I don't want that to be your first thought, maybe your 47th thought. Generally, that's not going to be something that you need to worry about. Now, if it's one of those complex situations where we're talking about an employee who is getting health care through a self-funded health program, then maybe pick up the phone and call legal counsel when we get into talking about disclosing information. But in general, if we're talking about schools, I would focus, especially when we talk about students, I would focus on FERPA first. And during this pandemic situation, when we're talking about disclosing private information for an employee, generally we don't want to do that. You don't want to make a comment to the public in general, but we would want to work with our local health department. And in that case, I should make another caveat. If you're working with a health department releasing that sort of information, I would not get too detailed as far as information for the employee. And I'm thinking in particular of the Americans with Disabilities Act and guidance that has come out that said, if we're talking about students, if we're talking about employees, don't disclose the name of students or employees in particular, because they're considered individuals with disabilities. But the general takeaway is, I know there was a question about forms. I wouldn't overly worry when we're talking about forms as far as HIPAA, unless it's a very sort of complex situation. And certainly, I don't have the time to go over all of HIPAA and all of those situations right now.
But if in our health department, one of the things that in the return to school roadmap it does require is that we have to essentially assess whether kids have symptoms or not. So do I have 100.4 temperature or not? Have I had a severe cough or loss of taste or smell? So there's a series of 5 to 10 questions based on the county. So if the school is collecting that data, is that then protected under FERPA, or is that more of a HIPAA issue? Because some people are doing it on forms, and I've seen it where forms are out on tables, kids are filling them out and leaving them on the table. I've seen Google Forms, and I've seen information systems, if you will, like a learning management system or that use it. So under those 3 different types of things, does the school need, if we're collecting that information about their symptoms, is that HIPAA because we're required to do it, or does that fall under FERPA with the medical piece under an emergency exemption? And does it matter whether it comes through a Google form, a learning management system, or paper?
I would not about it being a HIPAA issue. I would consider it a part of the student's education records under FERPA. Unless
so
something
that information is not being made public to anybody who's not a student of an educational right to know. So if a teacher sees that because they're in their classroom, or the counselor or the school professional, that's one thing. But if we're sharing that with students and families that aren't that student, then that would be the issue, regardless of whether it's paper or electronic.
Yeah, that's right, Colin. At the end of the day, FERPA, and Kevin, if you could get me to the next slide, FERPA is of course a statute that is about not disclosing private student information to other people unless there's an exception that applies. So when we talk, I mean, certainly you don't want to have a form out there where people, hop on a Google Doc or something, and all of a sudden they're all filling out their personal information that everybody can see. I mean, obviously we don't want to do something like that. But the having a form in general doesn't really make me as nervous, given that we're really talking about disclosure. And I think that, I mean, that applies to both of these prongs that I have here, whether it's, screening and symptom tracking, or whether it's a general wellness check or a mental health assessment or something like that. I think that's generally applicable to anything falling under that, the ambit, the umbrella of that. So I had this question here. What do I do if a student tests positive or shows symptoms at school? And this is, I think by now we're all pretty much on board, and this should be standard operating procedure as we move forward. But obviously we're going to want to isolate the student into a quarantined area until pickup can occur. And then you're going to want to contact the local health department. And as I mentioned before, you're going to want to comply with confidentiality laws, but under FERPA, a health and safety emergency, and certainly risk of a student who tests positive or who is suspected of having COVID would be an emergency to the health of people who have been in close contact with that student. Certainly that would qualify. So you're going to want to work close with the health department. There, I mean, at this point, they should, I would hope, all be pretty working very efficiently and know exactly what they're going to want to ask you for. And I would work that way. I did see I saw something pop up in my feed here as far as, if I can find it, which was the question, can we replace student with staff, with the question. And yeah, I mean, assume, of course, FERPA does not apply to your staff, but even in a situation where one of those crazy situations where HIPAA were to apply, if you were to release information to a local health department, there is also a health and safety emergency under HIPAA. So both of those would be FERPA or HIPAA, it doesn't matter. Okay. I haven't really organized the staff issues into any sort of, under any sort of rhyme or reason. What I will say is that we've gotten in the next two slides, there have been a lot of staff, a lot of questions that are sort of common questions that have come up a lot. So I'm going to tackle those. I'm also going to have to hide my thumbnail. I can't look at myself so I can see the question. But the first question is do staff members be screened daily? And yes, this is from the executive orders. Hopefully everybody's on board with this. At minimum, a self-screening questionnaire. You know, are you showing symptoms? Have you been in contact with others who have COVID or have shown symptoms and probably have COVID? We should all be on board at that point. If a staff member comes up and says, are you paying me for this time that I had to wait if you do something? And I'm thinking in particular of something that would take a little bit longer than a simple screen, maybe waiting in line to have your temperature taken. In those cases, yes, staff probably is going to have to be paid because even though it is mandatory that staff be screened, if they're waiting in line for something that you require them to do, like taking a temperature, then it's not like they're commuting to school where they don't have to be paid for that time. Staff are probably going to need to be paid for the time that they're waiting once they're already at school and in line. Then can staff or the school district be held liable if a student transmits COVID-19 to another student in class? So I'm going to shift from sort of the labor and employment mentality above straight to government immunity. Usually we're protected. Usually a government employee, a government body is going to be protected unless an exception applies. Now, I have sort of in the dark places of my mind that I go thought about horror scenarios where maybe a student, you have the sort of rambunctious prankster student who, is always telling tall tales, saying crazy things. And that student comes into class and is a runny nose or is coughing and pulls down his mask and coughs on another student and says, "Ha, now you have COVID," or something like that. And they sort of, rolls their eyes and thinks, it's just Tommy being his usual prankster self. I'm going to have to give him a talking to, but then does nothing. And in those situations, the legal term is gross negligence. If we're talking about something like that, it's sort of a horror scenario where I'm thinking of where, maybe the school is going to be liable. But those, I would hope something like that doesn't happen. I think it's sort of like, generally you're going to have government immunity and you're not going to have to worry about, as long as you're following executive orders, and as long as you're following the roadmap, and as long as you're following your district's policies, a student transmitting COVID to another student or to a staff member is generally not something that is going to trigger a liability on the district's part. Now that being said, it's sort of like in marriage or in calling airstrikes. So it is here. You're going to want to keep an open channel of communication and make sure your staff are well aware that they need to really let you know if anything out of the ordinary like this is happening, so appropriate action can be taken. Because again, I'm thinking that terrible situation where you have the prankster.
Adam, airstrikes? Come on, man. Adam does a great job. Adam does a great job, and he's a superb researcher, and he has given you the parameters of the law. I've been doing this a lot longer. That's why I don't have any hair left. Don't worry, Adam. You'll get there someday. Right, Colin? Colin knows. Here's the deal. Don't spend a minute worrying about liability, okay? Adam's right. It's gross negligence. It's conduct so reckless as to demonstrate a substantial disregard for whether an injury occurs. That ain't happening right now, okay? We're all going to be overprotective and over-responsive. So I think Adam's point, airstrikes in marriage notwithstanding, is not worrying about liability for those types of situations, is a more succinct way to say it. He's right to bring it up, and he's hitting on the legal elements. But that's not a concern that we need to have unless somebody basically goes bananas and is really acting in a reckless way. We don't have to worry about liability.
One last thing.
Go ahead.
With that, a little less, I'm going to step back just a minute because I missed this question when you were talking the FERPA part. One of the questions that came in is if a teacher records synchronous instruction, so whether it's Zoom or Google Meets or whatever they're using, and they're recording the lesson and we're in gallery view, like, our panelists are now, and it includes students, or if it doesn't include their face, but it has the text chat and stuff going alongside, so student names and information is there, can that recording be posted either one online for people to see or in-house for other classes to view, or would that be a violation of FERPA?
Anya, I think you've looked at this, haven't you, this issue specifically? I don't want to put you on the spot, but I think you had looked at that issue specifically of posting live stream versus recorded class sessions.
I have looked at this issue. If it looks like this is specifically about recording though. And if you're showing the recording to another student in the same class, that student was already in the class, the student already overheard it. There's nothing wrong with sharing that with that student. In addition, if you're sharing it with a different teacher and it's for an educational purpose, there's likely no FERPA issue there either, because both teachers are probably entitled to see, or not entitled, but there's no violation of the law in order for both of them to see it. That being said, the only really FERPA-related issues when it comes to recording classes that are virtual is whatever software you're using. Because if you're using Zoom or some third-party software, you need to check with legal counsel to determine whether that software is actually keeping a recording themselves, which some of these companies do. So that is really the only FERPA violation that you should really be concerned with. Is what the software is doing.
If I teach English 9 first hour and I have all my students on it, and rather than teaching it again second hour, I just play my recording and it includes all the first hour kids. That's not a FERPA issue. Is that what I heard you say?
I wouldn't really recommend doing that. I mean, if it's live instruction, I feel like you probably should be interacting with the students in a live kind of environment. Is that, I guess, Kevin, do you have any addition to that?
So, Colin, are you saying that they're supposed to be teaching live, but they just want to show a video of the first hour class to the other 5 classes of the day?
It could be that, so Anya took the first example where maybe somebody was absent from first hour class, so I play them the video. You said no problem, that's not a FERPA issue. They're part of the class, they just happen not to be there then, no problem. Second example, let's say another teacher wants to use that lesson, but it includes your students' questions, comments, faces. So that teacher's using it to instruct another class, but you're the one actually teaching it. And it includes the students from the other class.
Right, so questions that students ask about the curriculum or about topics that the teacher is discussing, those aren't things that need to be protected by FERPA. What needs to be protected by FERPA is personally identifiable information about an individual student. So if a teacher is in front of the class, and I'm sure teacher would never do this, and says, "Hey, Johnny got a C on his last paper," that's the type of information that we want to prevent other people and other students. We want to prevent disclosure to other people. But if it's just a round table kind of question and answer about the curriculum, we don't have to worry about a FERPA violation.
Yeah, I think that's right. And I mean, the idea is, not that we have a lot of movement in high school classes, but technically there's probably not a huge difference between whether you sit in third hour or first hour, or maybe because you're going to be out in the afternoon, maybe you go to a morning class and sit in that section so you can get the content. That's not so much the issue. It is that personally identifiable information that I don't think there's going to be a lot of that going on when it's being recorded, but that is the issue. Anya's right. It's that PII that's the issue.
Thank you.
All right, Adam, I'll advance your slide here, brother, so you can do your last slide when we get there.
Fair enough. And I'm going to go over this last one very quickly because I've shortchanged myself on my time allotment here, I know. But I will say that back on your previous point, I just wanted to mention that, yes, during the pandemic, certainly we're going to be given a lot of deference, because I think everybody understands that I don't like using the terms unique and unprecedented anymore, because I feel like I've heard them to death. But truly, that is where we are, and we shouldn't be casual about our requirements. We shouldn't be casual about what we're obligated to do. But we're going to get the benefit of the doubt when we're acting in good faith. Okay, so. I've got a few more questions here. Just gonna rattle them off very quickly. What do we do if an employee calls in and says his or her child has COVID-19? There's a lot that's been made out about federal paid leave. I do want to mention very quickly that if an employee calls in and the child and his or her child has COVID-19, then there's an executive order in place that permits the employee to stay home for a certain amount of time. As opposed to the very robust federal legislation, part of the problem of executive orders can be that they are there's a lot more holes in them. They're a lot shorter, and they don't last as long, obviously. But in this case, teleworking is mentioned in your federal paid leave provisions, but not in your PMLA executive order provisions. So if you have an employee, for example, who is taking care of a child at home, or even if they have COVID themselves and are asymptomatic and are totally fine, if they are at home under this executive order and they say they've exhausted all of their employer leave, they don't have any sick days, they first burn sick days, and then after that they don't have any sick days left, they get an unpaid leave. So there might be situations where, generally an employee is going to be able to stay home while they have symptoms like that, and they will not be forced to telework while they're burning sick days. Okay, can an employee stay home and demand to work remotely simply because they fear contracting COVID? What about executive orders requiring remote work where capable? No. We should, of course, be aware of when people when somebody tells us that because they have a certain disability, they are at higher risk of contracting COVID and they need to work remotely. Then perhaps in those cases, but not simply because they're afraid of it. The other thing that I want to mention very briefly is that if the say the union comes and says, this executive order says that all work that can be done remotely must be done remotely, and therefore all the members of our union, all of our teachers should be able to work remotely and not have to come in. That is not compliant with the roadmap, and the fact of the matter is administrators have the prerogative to have folks come in and and perform remote live instruction. I'm going to shift over to Anya here in a second, but I sort of had this last, we are overwhelmed with our paid leave requests, and basically, you know, we're really short-staffed because of the pandemic situation. What do we do? I don't have a good answer for this. I know that everybody's sort of in the same boat. And I am hopeful that by treating these situations compassionately, understandably, and again, communicating, we will be able to get through all of it, you know, not without no problems, but, you know, we'll be able to get through it. Okay, I'm going to switch over to Anya at this point. Thank you.
Thanks, Adam. Appreciate it, bud. And you weren't shortchanging yourself on time. You shortchanged Anya on time, but that's okay. And Tammy, but that's all right. That's all right. It's all important stuff, and there's a lot to digest, and it's a challenge to cover all that stuff, but in 4 slides. But without further ado, what everybody wants to hear about, masks and what to do. Anya, take it away.
All right, I'm going to do my best to get through this so that you guys have enough time for a couple of extra questions and for Tammy. So I'm just going to dive right in. So, well, actually, I'm not. I'm going to give a little introduction. What Lusk Albertson did is we released recently a mask FAQs guide, and it has 14 different scenarios that have actually been asked by various schools, and we compiled them and put them together in a document that we'd be happy to send. We also included it as part of the addendum to the legal survival guide that we released in connection with MASSP. So if you're getting a copy of that, the entire guide is in there. I've pulled a couple of those questions, and they're here on these slides for us to review now. So let's do it. So number 1, may schools request a doctor's note from parents claiming their student cannot medically tolerate a mask? Yes, you absolutely may. That being said, I would recommend that the note be relatively short and simple and limited in length. All it needs to say is, well, it has to have a doctor's signature, of course, and it has to be from an actual doctor. And all it needs to say, however, is that the student is medically unable to tolerate a mask. We don't want to get too far into the weeds with a particular diagnosis or any of the reasons really that the student would not be able to wear a mask, and we don't want to push back too hard on the parent. And the reason that we don't want to do that is because the roadmap is very clear. Students who cannot medically tolerate masks should not wear them. And that's all the guidance we have right now. So keep those forms simple and sweet, but you are allowed to ask for one. And if a student can't wear a mask, definitely offer some reasonable accommodations for that student. Talk about it with the parent. See if there's something else that the student can wear or something else that can be done to protect the student and protect the student's classmates. For example, a neck gaiter instead of a mask, a face shield instead of a mask. In addition, the teachers should be following the school district's preparedness plan, which schools, I believe, should have submitted by now or may need to submit soon. And that will have instructions for how classrooms are set up, if they're doing in-person instruction, to help kids stay socially distant and to make sure that everybody's protected as best as you can. Last resort kind of option is that if a student cannot medically tolerate a mask and your school district is offering virtual learning, educate the exempted student virtually if possible. All right, so that's the answer to question number 1.
Just real quick with that, if the person's in person, the question is, what accommodations do I need to offer a student with a medical exemption from wearing a mask to continue their in-person? So you mentioned like, hey, put them online, put them in your virtual, but what if that's not the option?
I also mentioned neck gaiters, which I don't know if you guys are familiar with neck gaiters. Instead of a face mask, it's kind of this much larger piece of fabric that covers the mouth and nose, but also covers the neck, and it's often actually worn as a headband and bandana too. They're not as protective as masks, but they might be an alternative for students who can't handle, especially the rubber bands behind their ears from typical masks. You can also try face shields. Ask the parent to get a face shield or offer a face shield, which is kind of a flexible plexiglass shield. Those are also, CDC says, not as effective as masks, but it is a reasonable alternative. And then worst comes to worst, you just have to let the student exist in the school district in person without a mask. Now, you're not actually required to offer any of these accommodations, but for the safety of the student, the safety of his or her classmates, and the teachers and the staff, I'd recommend doing so.
Thank you.
All right, how should schools respond to situations where wearing a mask is impractical? And this is one of the most frequent questions I get. And the most typical situations are things like during speech therapy services where you need to see the therapist's mouth and the therapist needs to see the student's mouth, special education evaluations, or when educating hearing impaired students. And this is the time where school districts need to get creative. And there are a plethora of alternatives. I've talked about a few of them already. Instead of wearing masks, so that you can do your job, your students can be educated, and that you guys all stay safe. And so there are clear masks and masks with clear panels. There are the face shields that I discussed earlier. And the clear masks, of course, will help you see the student's mouth and have the student be able to see your mouth. Physically distancing from students before removing masks, as long if you're providing, for example, speech therapy services, if you can sit in a room, you can be far enough away, you're social distancing, and you're allowed to remove the mask, but only for the amount of time that you need to in order, of course, to perform the therapy. Use voice amplifiers or similar electronic devices, and then you can use images or videos for demonstration purposes in lieu or in tandem with in-person services. So those are some alternatives when you cannot wear a mask to do your job. So can school districts discipline students who refuse to wear masks? And isn't this just the million-dollar question? So presently, there's no state or federal guidance on this issue. And across the nation, school districts themselves are actually quite divided. Some are saying, yes, absolutely, this is a pandemic, this is a public health crisis, of course we're going to discipline students. Others are saying there is no possibility that we're impacting the education of students because they won't wear a mask. So at this point, right now, it is really up to the individual school district until we get some guidance from either the governor or the courts. However, if your school or your district does decide to implement discipline, if a student refuses to wear a mask, I want you to consider a couple things. First, provide masks to students who will agree to wear them. It's possible that the student just doesn't have a mask at home, doesn't have the resources or attention at home to have one, but they'd be happy to wear one if they're offered one. Check to see if the student might have an underlying medical condition that not even the student is aware of. So sit down with the student, talk with them, try to figure out why they're not wearing their mask, reach out to the parents if necessary. And try to determine whether refusal to wear a mask is an actual disobedience or a symptom of a disability. Because if refusal to wear a mask is a manifestation of a disability, you might have to go through the MDR process. So make sure that you're thinking of that too. And talk with the parents. And I know that you're probably going to be sitting in a lot of parent meetings this year with regard to masks, but really, at this point, masks in schools for students who are able to wear them is non-negotiable. It is absolutely a requirement. And it's possible that the parents might not be aware of that. So talking with the parents is always a good option. And then if all else fails, and if your district is offering virtual learning, you may be consider requiring those students who refuse to wear masks to attend school virtually instead of in person. All right, next question. Should schools allow students who cannot medically tolerate masks to interact with their peers to the same extent as masked students? For example, sit at tables with other students or work on in-person group projects. Generally, yes. Best practice has always been not to single out or separate students who have underlying medical conditions. And you may have heard that and thought like, okay, Anya, I get it. We don't want to single out disabled students. Of course we don't. But this is a pandemic, and I don't disagree with you. That being said, historically, every time some unique and interesting situation has come before the courts have always said, do everything you can not to single out disabled students, don't separate them, try your best. And I think that this situation in the end ultimately will be no different. So just from a best practice standpoint, do not single out these students. Now, your school district will develop their preparedness plan, and there will also be a number of things in that plan that helps this situation where you might have some students in your class without masks. So make sure to read the preparedness plan, figure out what it is that you need to do inside your classrooms, and that should help as well. That's it.
So real quick, Anya, just a couple of quick questions. And first one I'm going to ask you, if a student is has a medical exemption, is it you may not require them to wear something? It's if they say no, I'm not going to wear a shield, I'm not going to wear one of those neck guards, you have to let it go.
Yes, ultimately.
Okay. Secondly, is a note from the parent, not a doctor, binding? Do you have to honor it?
Well, you don't have to get a doctor's note either. If the parent alone tells you that the student cannot wear, is medically incapable of wearing a mask, that by itself is sufficient. You actually aren't required to get a doctor's note at all.
I think
So
the opposite sense. If a district wants to require that, you can't require it, is what I'm hearing. If a parent says I don't want my child wearing a mask because of whatever that exemption is, you have to accept it at face value. Is that what I'm hearing?
yes.
Okay.
But if you want to ask for a note, by all means, and if the parent gives you one, then great. But you would have to accept it regardless.
Okay. So at the end of the day, it's going to come down to if a parent says, no, my child's not wearing a mask, you have to honor that. You can limit some ways, but you can't because of IDA or whatever, they have to have the fullest extent possible. If they don't have medical exemption and they choose not to wear the mask, that's where your FAQ comes in, and that's where you could take disciplinary action up to and including moving them to virtual option.
Right. That's right.
All right. Thank you very much for those. I know we have a couple other questions that are coming in here just real quick.
Yeah.
Is it reasonable to require Zoom background similar to the school dress code, respecting First Amendment rights, but disallowing inappropriate, profane, disruptive backgrounds or imagery, like a political background endorsing a candidate, or but a background promoting violence is not okay?
Unequivocally, of course, you absolutely may do that. The same rules that apply in person, the school districts can also apply them to the virtual learning setting. So as long as it's in the student code of conduct, it's something that that the school has historically enforced, they can continue enforcing it in the virtual environment.
Yeah, and Colin, we're getting a lot of questions like that. And I mean, look, we're going around telling our communities that this is going to be like school. It's just virtual. So it's like school, just virtual. And so if they can't wear a t-shirt that says, F whatever, they can't have a background that says F whatever. So it's the same deal. Anya's absolutely right. The code applies the same.
And I think that's a big thing for principals, just to know that even though the kids aren't on site, they're engaged in an educational activity. And so typically the student handbook is if you're at school, on school transportation or a student event activity, the student handbook applies. When you're in these lessons, whether they're synchronous, asynchronous, that you're in their platform, the handbook applies. So apply that piece. It may be a little harder to investigate. It may be a little harder to follow up, and the discipline may change, but the handbook's the handbook. Keep applying appropriate and reasonable measures in response to that.
And it might be really helpful to send out a letter at the beginning of the school year, an email, or however we contact parents to let them know that these handbook or code of conduct is applying equally to the virtual environment.
Yeah, setting expectations that this is just because it's virtual doesn't mean the rules are different. I agree 100%. Giving notice of that's important.
So the last one then is, can a family request that their hearing impaired student's teacher not wear a mask? I guess they can request. The question is, do you have to honor the request?
That should be the absolute last resort option, is for the teacher not to wear a mask. If the clear masks exist, the masks with the face panels exist. It's not ideal, but I've listed a whole bunch of alternatives in the one slide for, but not wearing a mask should really be the last resort.
One of the things that's important to note, and this relates to the employee situation, when people ask for accommodations, the accommodation they ask for doesn't have to be the accommodation that they get. They can ask for the accommodation, but you just have to give them an accommodation very often. And so Anya's right. There's a lot of alternatives before we get to take your mask off because that's the one I want. There's a lot of things that we can do before we get that. So giving the accommodation is not always required. We just have to give an accommodation.
Excellent. Well, thank you for that piece. The last one we want to do is if you stop sharing, and then Tammy Jackson is going to share a little bit about now, given this, what do we do?
Yeah.
And so I know we're right up around the clock with 2 o'clock. So if people are able to stay on with us, we'd love to have you. Otherwise, just before Kevin and them go, thank you for being here. We look forward to working with you in the future under Miller Johnson. Thank you, Anya and Adam and Kevin, for all you've done to make today so informative and to support us not only now, but in the past and into the future.
Appreciate it, guys. Thanks so much.
So with that, Tammy, if you could take over the sharing.
I sure will, Colin. Thank you. Are you seeing my screen okay? Are we good? Okay. Thanks. That's really good stuff. I could really spend lots of hours listening to that stuff. It's so important. So I'm going to spend less time, and I'm just going to talk a little bit about how restorative practices can help you manage and mitigate some of the issues that we talked about occurring today. We know that when students come back to us, we know that our students are worried about their grades. We know that they're worried that they have forgotten content. They're concerned about the fact that they're out of practice for being in school. They want to socialize with their peers. They're afraid they're going to get sick. They're wondering if the pandemic is going to put them out of school again. And quite honestly, they're wondering, are adults telling them the truth? Because they're hearing so much stuff, they don't know what to believe anymore. We know that these students are going to need a transition time to bring closure to what they left in March. We know that they need assurances that we are going to review content and help them catch up and close the gaps. We know that they will need us to explain to them how their GPA and grade is going to be affected by what happened last year with grading. We know that they need time to socialize and reconnect, and that they need a clear understanding of expectations moving forward. And they need to hear the same narrative from all adults. We know that that's really important. So knowing that, restorative practices, when you have that in place, you really are in a better place. Restorative practices is really about 25% managing student unwanted behavior and 75% about creating a culture where students feel safe and valued and are more likely to not display unwanted behavior. Actually, in a time of crisis, your current culture will dictate the response of your students and staff. And if you are already using restorative practices in your school, you're really one step ahead. When we talk about restorative practices, we talk about meeting the needs of our students. We talk about the hierarchy of needs, making sure that they are physiologically content, that they are safe, that they have love and belonging. We call it Maslow before Bloom. You can't get to Bloom if you don't take care of their basic needs. And we saw someone said this earlier, well, what kind of a need might there be? Well, one need might be a face mask, right? If students don't have a face mask, you have to give them a face mask. And if they don't have a face mask the next day, you have to give them another face mask. We have to remove the barriers that would keep them out of school and keep them from being safe, because we just really don't know what students are coming to our classrooms with. We know that kids have experienced a tremendous amount of trauma, and they've experienced that. They had already experienced it, or maybe it's a new trauma. But students being home and away from school for a lot of time isn't good for many of our students. And it's important that we understand how trauma impacts the behavior of our students and how trauma blocks students from learning academically. So what restorative practice does is it includes lots of preventative measures. For example, the social discipline window talks about our behavior. What is our behavior? Are we a permissive teacher? Are we a neglectful teacher? Are we punitive? And I don't just mean teacher, I should say staff member, because this could apply to any staff member. Or do we do things with students? Do we honor students' voice? Fair process, meaning, did we let our students be a part of the plan to deal with COVID-19? If you haven't done that yet, start now. Let them in on what's going on and listen to them. Student voice is so incredibly important. And when you allow students to share their voice and you listen and then you do something with what they have to say, you will change the culture in your building so fast. We also talk about circles. Circles are a great way to talk with our students about what's going on. Talk to them without judgment. Allow them to voice what's going on and what they felt, what their experiences have been like. We talk about being not judgmental and authentic. Let's face it, if we sit down with our students when they first come back, the first day they get back, and we say, look, we are all in this together. I have to wear a mask, you have to wear a mask. We all have different beliefs about masks. Some of you may believe that it's a hoax and that you shouldn't have to wear a mask. And some of you might think that it's, that you're really concerned about your health or the health of the people that you are exposed to. And that's okay. What we're here to do at school is we are here to follow the law regardless of our beliefs, so that we can all be together. When you have those honest conversations with kids, they get it, and they remove you from the rule, and they say, well, she didn't make up the rule, she has to follow the rule as well, and they are more likely to be respectful and follow that rule. And then when they don't, when you talk to them with restorative questions and you ask them what happened and how are you feeling about that and what's your plan moving forward, all those things will help students feel like you're listening to them and you really truly care to help them solve the issue at hand. Every school should have a step between not wearing a mask and being suspended. There needs to be a step there. Where do they go? What do they do to process it, think about it, and then make a better decision once they're able to about whether they're going to stay in school or go home. All kinds of training on this. Honestly, we could go on forever, but just letting you know that if you are interested in restorative practices, your entire district, every staff member, certified and non-certified, should be in a 1.5 day introduction where we focus on the research and the beliefs behind the practice. And then from there, typically a building team will meet and go through another full day of training, and then another day after that with that building team to start planning and implementing. So lots of steps through where we go with this, but if you're struggling, if you're wondering how you're going to manage all this, and would like to learn more about restorative practices, give us a call, and we've got some great materials that will help shift your culture in a quick way.
Thank you for joining us today, and Tammy for providing that little overview about how restorative practices fit to the return to school and how we can support you. We appreciate everything that you have done for us, and as an association, we appreciate our members and giving up time to be with us, particularly for this additional time after 2 o'clock. Please note, as noted earlier, we will be providing a copy of the handouts, the FAQ that was referenced, as well as the recording that will come out in our next headlines on Monday morning. So please do look for that in headlines. It will be the Leader2Leader recap. And it's also, I put the link to where it is on our website in the chat. So with that said, thank you for being with us, and we wish you well this afternoon and into the continuing to the start of the school year.